put up, and then the back and forth, the conversations, the precedents under Speaker Okoye, and now what Speaker Bagbin could possibly decide. What are your initial comments from where you sit?
My initial comments are that the moves currently happening in Parliament, culminating with the eventual decision that Speaker Bagbin will take, even including the outside activities that are likely to happen in the courts, as per the suit filed by the majority leader, will all have the potential to shape the future of parliamentary work going forward. And depending on how these are done, when done right, it will shape the future of our parliament properly. When done wrong, it will also have some very, very dire consequences of our parliament, for which reason all of the actors must bear in mind, especially Speaker Bagbin, that they have a crucial decision to make, and they must make that decision with the long-term implications in mind, with holding fidelity to the Constitution of our country in mind, and also being minded about the fact that the precedents that get set today will come either smiling at us in the future or biting at us.
The actions taken then by Speaker Michael Okoye, which was endorsed by the Electoral Commission at the time, led by Jean Mensah, who still is at post, has been called the mistake of yesterday by a respected member of parliament in the heat of the debate. Was it indeed a mistake from where you sit?
I think so. And I think so with all due respect to Speaker Michael Okoye, and bear in mind, his stature, knowledge about the law and the political, conditions within our country over the years and what have you. But I think so because we know that even at the apex court of the land, we know that in our parliament, we know at the executive branch of government, decisions are taken sometimes not entirely due to the black and white letter of the law, but also taking into consideration national cohesion, public policy, future implications, and all of those. And that is why I felt that Speaker Okoye then could have hesitated in agreeing to the street cries of the NPP at the time, including a letter that was sent by the General Secretary of the NPP at the time, which eventually became the basis for which Speaker Okoye went on to provide the ruling. With the benefit of hindsight, I'm sure that if we would be truthful to ourselves, the actors or the players within that particular situation would have wished that that decision was not taken at all. Why am I saying this? I'm sure that on your show and, of course, in the public square, many conversations have gone on about Article 97(1)(g) and its implication. And I don't intend to belabor that particular point. But I hold the considered view that when the Constitution in 97(1)(g) said that you lose your seat if you are a member elected on the back of a political party and you seek to stay in parliament as an independent, I think that the Constitution meant that you seek to stay in that same parliament as an independent, and not when you've served notice that should you get the chance in the next parliament, you'd want to come in as an independent. Those are two separate things, and we need to look at it in that particular context. Because what then is going to happen? And I know that for the political parties, this may also be a way for them to push to show that, to scare people away from wanting to decide to go independent if they are members of parliament and they lose their party primary. So, serving them notice that, well, not only would you have the party's full force coming up against you in the constituency, but you'll also lose your seat in parliament. But let's look at the practicality of it. We're just 2 months to elections, and there was a similar situation in the 2020 case. In fact, the MPP letter to Speaker Okwe was, I think, dated the 13th of October. Speaker Okwe delivered his ruling on the 7th of November.
Right.
And so even at the time of his ruling, we're just exactly 1 month to elections. With 1 month to elections, with Parliament at the time almost finishing with its work, and all of that, what will be the utility of declaring a particular seat vacant simply because the person had indicated that they intend to join the next parliament as an independent? Does that mean that if we have so many defects from political parties going forward into the future, we're going to have many, many seats declared vacant? Of course, Speaker Okwe's argument at the time is that the political party then, the NPP, had written to him to say that that member of parliament for Fomena was no longer a member of their party. And because he's no longer a member of their party, cannot continue to hold the office of an MP. And that is why he took the decision. And if you listen to an interview I heard he has granted recently, he says that the reason why the current situation is different from his situation that he handled is that the political parties now have not communicated anything to the speaker to say these people have lost their membership.
Right.
And once that has not been done, we cannot consider them to have, relinquished their seats. So are we saying then that, if the NPP, which decided to communicate based on the same constitution, which has not changed 4 years ago, that people had lost their seat simply, or someone has lost his seat simply because he relinquished his position, or he filed as an independent, and now says that with that same constitution, others have filed nominations as independent, but this time around we are not communicating anything because it's our own constitution. We decided to do with it what we like or otherwise. Is that the kind of legal jurisdiction that we want to have, where people can pick and choose when it suits them and it fits them most to approbate and to reprobate? Well, I think that is where the lacuna is, so far as the 2020 ruling of Speaker Okwe is, and that's the challenge that it has created for us now.
I hear you. Let me engage Honorable Alexander Kujokom Aban, who's a former member of parliament for Gomoa West in the Central Region. Council, good morning. Thank you for your time.
Good morning, and good morning to your cherished listeners.
Great. You have sat in the chamber before. You have also read the law and practiced the law. The law is being quoted left, right, center. Legal arguments are being made here and there. First, I want you to wear your hat as a former member of parliament and tells me what the mood and the feeling was like in the chamber when Speaker Okwe took a similar decision which the public may be expecting Speaker Bagbin to take today.
Thank you very much. I had my own personal emotions towards it, if I may put it that way, because at that time, I was sitting close by Mr. Andrew Esiama.
Right.
Beyond that, we were very good friends, and we shared, if I may put it that way, some kind of history together, because we all had the benefit of going to the seminary, and we all left the seminary. So he was my friend.
Six to six story.
So I had my own personal feelings about it. That my friend would be ousted at the last minute. But I think we should draw two lines: the politics of it and the law of it. Now, if you look at the Constitution, which states clearly that final judicial power rests with the judiciary, the question we have to ask is whether, in giving such a ruling, the Speaker was exercising a judicial function, or he was just dealing with legislative function.
Right.
That question is hanging because now it has become even more imperative because some people think that if you just give an indication by your conduct that you wish to return to Parliament, not remain in Parliament. I'm using my words carefully.
Right.
You wish to return to Parliament on the ticket of one party or the other.
Right.
Apart from what the tickets that sponsored you into Parliament. Would that merely mean that because of that indication, you should be ousted now? Because my understanding is that if you wish to remain in Parliament, and there's absolutely something to be said for why each Parliament has its name. So this is the 8th Parliament.
Right.
And so if you want to remain in the 8th Parliament, having been elected there on the ticket of, let's say, MPP, and you want to remain there this time round as to be recognized as an independent person or as having crossed capital, let's say CPP or any other political party, then this clause will kick in that you should be, your seat should be declared vacant, and then if you want, go and contest again on the new ticket that you have adopted.
Right. In giving that ruling in 2020, if you read the Hansard, Speaker Quay is quoted as saying that going by purposive interpretation of the present law, constructive actions on the part of the MP is important. With all intents and purposes, he is no longer a member of the party. He has pronounced himself publicly as an independent candidate and has filed papers to compete against the party and its official candidate as an independent candidate on 7 December 2020. On that occasion, this current parliament will still be sitting and operating as an official Parliament of the Republic of Ghana. We shall not have a situation adopted freely by any sitting MP where he or she would be campaigning openly against the party that he or she will still represent in Parliament and yet ridiculously stands against the party. No purposive interpretation of law would allow such ridicule to prevail. This was Speaker Okoye's reasoning, and which he followed through by asking Mr. Siama to leave. What do you say to this?
I'm thinking that at that time it was the politics of it more than the law of it.
Right.
I'm being honest with you. And most probably, if we had the numbers like we did in the 7th Parliament, I'm sure MPP would have been glad to oust this vote here and now.
Right.
But its political effect looks so suicidal that they would not. And it's not only about MPP. I'm sure if the tables were turned and it was the NDC's time, they would also do so because the ultimate aim would be to prevent people from doing this. It is because the numbers are so tight and knife-edged that you risk your own political suicide if you embark on this course. And that's why probably no letter has been written by NPP to the Speaker. The question that I'm still asking is, do we just infer from the conduct, or we should take it that the person should officially communicate to his political party that I have left? Now, if you look at the NPP constitution itself, I cannot quote the exact provision.
Right.
But it's clear, black and white, that if you did anything like what Cynthia Morrison has done,
right,
you automatically, because these were the words, you automatically lose your membership.
Right.
Which law are we interpreting here? Does NPP as a political party have the leeway somehow to suspend the application of certain provisions of its constitution. Sometimes they will tell you that for political convenience, political expediency,
FM
certain things that
92.7.
are clearly stated black and white in our constitution may not be applied strictly for political reasons. And so if we come from that angle, that may be a reason why MPP hasn't written. The other side of it is that the candidates themselves have not given
3
any
FM
official communication to
92.7.
their political parties. And as it stands now, they have also not communicated officially to the Speaker.
But Councillor,
That
action speaks louder than words, doesn't it?
That is why I'm asking whether we are taking it that just by conduct.
Right.
And this conduct, if we are looking at it clearly, it's a declaration of intention
3 FM
that in the
92.7.
next parliament, I wish to come in a different style, if I should put it that way. Right? But the operative word in Article 97, 1, G, and H
Right.
is to remain in parliament. Remain in parliament.
Right.
In which parliament? In the 8th parliament. Have they made any such communication? Or we are just inferring from their conduct?
Well, if the Electoral Commission, if the Electoral
they may say that, they may say that, yes, in the 8th parliament, we want to remain as MPP persons.
Right.
But in the 9th parliament, we want to come as independent candidates.
But there's a process to coming back to Parliament in the 9th Parliament. And that process begins with filing your nominations. That process begins with campaigning. That process begins with the Electoral Commission publishing the names of persons who are qualified to contest. That includes ballot sheets and etc. All of those things will point towards a certain direction. And as I read to you, Speaker Okwei's reasoning was that you cannot be, on one hand, representing a political party in the House, and then on the other hand, publicly campaigning against the political party on another ticket, trying to be in that same seat. It doesn't work like that. You can't eat your cake and have it. So that reasoning by Speaker Okwei, which was upheld by the Electoral Commission and by Parliament, and that happened, is what has become the conundrum today. Where do we go from here? And I'll bring Sami in shortly. But where do we go from here?
I have two questions. Does that
3 FM
conduct
92.7.
deny the person the mandate that he has for the 4 years? Because it is in preparation towards a certain 9th parliament, which is yet to be born. Now he is in the 8th parliament. Okay?
Right.
Does it mean that because of the preparatory works being done towards the best of 9th parliament, I should lose the mandate that I have when I have not declared that I want to, if I say, truncate the mandate that I have for the 8th parliament? And that's what I'm asking, whether we can just do this by inference or we have to insist that if indeed a person wants to cross carpet here and now, he must bring some kind of formal communication. And so the second question I have is, in giving this ruling,
3
was
FM
Speaker Okwei
92.7.
interpreting the Constitution, or he was just dealing with legislative matters? And this is where the issue of all these things about conduct and all that may be for the interpretation of the Supreme Court.
Would you rather Parliament wait for the Supreme Court to give an interpretation of the relevant portions of the law that are being quoted now, or that Parliament goes ahead because you are a master of your own rules and a separate wing of the government, separate arm of the government? Would you rather that they wait for the Supreme Court or that they go ahead and take a decision?
I think that they should wait for the Supreme Court. And I'm going to give you a reason why I'm saying that.
92.7.
You see, being a master of your own rules would never extend to you, if I say, encroaching on the turf of the Supreme Court. So long as we have different interpretations, it means then that there is actually condition of doubt. And that doubt must only be cleared by the body that has been established by the Constitution or created by the Constitution with a mandate to do so. So if that is the case, let us deal with the constitutional interpretation of it. Whether by the preparatory acts of a person, which clearly indicates that in the next parliament, he wants to break ranks with his party, it's enough to say that it has kicked in now, so he should be ousted.
3FM
Or
92.7.
it is only when the lives of the 8th parliament or the relevant parliament has ended, especially when the person has not even indicated formally that I'm breaking ranks with my party. Should we take it from the conduct, or we should wait for formal communication?
I hear
That's
you.
point number one.
I hear you. Counsel.
I'm going to take my point.
Right. I get your point. I get your point. And your questions, your two questions, I'm sure the speaker will consider your two questions in trying to give his reasoned ruling today, as we all anticipate the speaker to make that determination. But thank you very much indeed for your time. Honorable Alexander Kojo Aban, former MP for Goma West, the Central Region, and also a private legal practitioner. We're grateful for your time, sir.
Thank you, sir.
Ms. Obing, I come back to you. What could possibly happen if Speaker Bagbin decides that, okay, 3 MPP MPs go, 1 NDC MP goes, and then the majority side becomes the NDC, or the minority side becomes the majority side? What could possibly happen? Why are we all over the place?
Johnny, before I come to that, if you would indulge me briefly to
Go
indicate
ahead.
that I couldn't have agreed more, with Honorable Kojo.
Right.
And you see, it is always refreshing when we interrogate such matters devoid of the politics, right? And it has a way of
92.7.
allowing us to put across the issues well. I'm happy how he put it about the fact that the situation in 2020 was about the politics of the day and the law of the day, and how he broke this down into the politics of the day and the law of the day. And let me just add quickly to that look at Kumewu in the recent by-elections. Somebody contested as an independent candidate. He was a member of the NPP. Just after the elections, although he has indicated to have been expelled from the party, I guess the NPP went and they've reconciled and he's back into the party, isn't it? If I'm not mistaken. Now, it is their own constitution, but the party decided to apply the constitution differently. In 2020, they decided to write. In 2024, they are saying we have not written. If another political party also has a clause in their constitution that says that if you declare your intention to oppose our candidate in a particular contest, we will take you through a hearing process. You have the opportunity to be heard, blah, 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 before your membership will be taken. And that could probably take about 3 months. Does that mean that in that instance of that political party, if their case comes up in Parliament in this way, Parliament will have to wait that 3 months to be able to make the decision? It will be a mixture of playing to the whims and caprices of the political parties as and when. But now to your substantive question of, and that would be a dangerous situation. And maybe on the legalese side, maybe one of the opportunities we missed in 2020 and beyond was that because Honorable Isiama won, nobody really took up the matter, including himself, to the courts, for the courts to have made that proper interpretation of those provisions of the Constitution. We wouldn't have been where we are now. And in my opinion, whatever happens, we should be interested in having the courts determine this matter so that the future would not be pregnant with ambiguities like we find ourselves now. But should the ruling of Mr. Speaker go in a particular way, and that's your question, what would happen?
Right.
Should it go in a way that says that, well, all 4 members of Parliament, your seats are declared vacant? A few things. One, inside of Parliament, it means that the number dynamics will change, and
Right.
that would add an additional layer to the litany of
92.7.
surprises that this 8th Parliament has produced. From a Parliament that started with ballot snatching to soldiers invading the chamber, to a speaker who is not a member of the ruling government, to throwing of blows, to sitting on somebody's lap because you have taken my seat, to who is majority, who is minority, to majority group. This will add another layer of a Parliament that ended also with the party that is not in government being the majority in Parliament. With elections just around the corner, we know how politicians can take advantage of every situation, no matter how little. And so we can expect that if this happens and the number dynamics change, the NDC will try to exploit it as much as possible to their advantage, with elections being just a few minutes, a few days away. We also know how that may affect government business. And all of these things needs to be considered, very much. Outside of Parliament, should that decision be taken, there necessarily must be effort to ensure that the courts provide a clear interpretation of this matter once and for all. So we do not leave constitutional interpretations to the discretions, whims, and caprices of speakers of Parliament, who are politicians by and large, and at one point or the other would be seeking to do the bidding of a particular political party, and the future will not be too good if we leave it necessarily in their hands. And then the third angle, if the conversation goes on that way, will be for us to now start interrogating how the politics of these conversations versus the law of this conversation, as espoused by Honorable Kojo earlier, will have to play out going forward to ensure that taking away the mandate of a group of people who have selected their elected representative is not considered the same way as representing their party. One of the flaws of Speaker Okwe's ruling is where he stated, and the portion you read, where he stated that as somebody who is representing a party, MPs don't represent parties in Parliament.
They represent the people.
Absolutely.
I see. Sammy, I want to thank you for your time, but before you go, for students of political science and students who are interested in the kind of work you do from inside and outside of Parliament, how important should this matter be to them? Should they be following it like they have an exam to write on it?
Oh, absolutely, Johnny. 2 days ago, I was following it as though my life hung on it, the debate that was going on. Not because PR Africa pays my salaries every day, but it is also because these things shape our country. And for students, of course, like you described, whether studying political science or not, in fact, I was actually watching it on Facebook Live, and I could see the conversations and the debate. I could see how people were trading even insults. When Speaker Bagbin says that he was going to defer the ruling for a couple of days, I could see how people said, oh, no. He's waiting for a few days to go and do consultation, to do certain things and come back. People were expectant and what have you. However, the precedence again was that Speaker Michael Quay got a letter on the 13th of October. He delivered his ruling on the 7th of November, almost 1 month after, the issue had come up. And this is because he said he needed time to ponder over the issue. That's how some media houses had captured it as a 2020. Isn't it also quite interesting that the Haruna Idrisu campaign declarations on the subject matter, which I think happened over the weekend, which has brought back this whole conversation, it happened on the 13th of October in an election year, when the NPP letter also to Mr. Speaker was on the 13th of October in the previous election year. So these things, it means that in October, in every election year, with people losing their primaries, these things will come up. And that's why we need to deal with them once and for all by a proper interpretation of the Constitution and not leaving it to the whims and caprices of speakers who maybe 4 years down the line will sit down and grant interviews and say, well, my case was different. That's why I said it this particular way. Your own case is different. Go and do fiasco.
Samuel Bing is Executive Director of Parliamentary Network Africa. Sami, thank you very much. Always refreshing to have a conversation with you.
My pleasure always, Johnny.
Great. And that's Samuel Obing. It's some 7 minutes after 9 here on 3FM 92.10. I'm sure you're wondering what's in Article 97 of the 1992 Constitution that's being quoted left, right, center. Well, let me share the detail with you if you already are not aware of it. Article 97(1) of the 1992 Constitution says a member of Parliament shall vacate his seat in Parliament, A, upon a dissolution of Parliament, or B, if he is elected as Speaker of Parliament, or C, if he is absent without the permission in writing of the Speaker and is unable to offer a reasonable explanation to the Parliamentary Committee on the privileges for 15 sittings of a meeting of Parliament during any period that Parliament has been summoned to meet and continues to meet, or D, if he is expelled from Parliament after having been found guilty of contempt of Parliament by a committee of Parliament, or E, if any circumstances arise such that if he were not a member of Parliament would cause him to be disqualified or ineligible for election under Article 94 of this Constitution, or F, if he resigns from office as a member of Parliament by writing under his hand addressed to the Speaker of Parliament, or J, if he leaves the party of which he was a member at the time of his election to Parliament to join another party, or seeks to remain in Parliament as an independent member, or H, if he was elected a member of Parliament as an independent candidate and joins a political party. So that's what is contained in Article 97 of the 1992 Constitution. I'm sure you've heard the lawyers explaining all of these things. Now, I want to get onto a conversation with a veteran politician, as also a very well-respected parliamentarian, the Honorable Cletus Avoka. He's also a private legal practitioner. He's MP for Zebela. Counsel, Honorable, good morning. Thank you for your time.
Good morning, John.
Good to hear from you, sir.
And then good morning and good for the work that you have been doing.
Thank you, sir. I'm grateful.
Keep it up.
Thank you, sir.
I appreciate you a lot.
Great. You have been in Parliament for a very long time. What do you think of what's happening now in Parliament regarding 3 MPP MPs and 1 NDC MP? Honorable Aaron Idris is asking that they go the way that MP Formina was made to go under Speaker Kwe. What do you think?
Good morning again to your listeners.
Yes,
I'm not just a senior member of Parliament, but I was a member of the defunct Consultative Assembly that drew the 1992 Constitution.
Right.
So I know the spirit behind many of these provisions that we have made in that Constitution.
Right.
We took account into best international practices and also our past history. You recall that in the First Republic, under the CVC administration,
3FM,
it was commonplace for people to be elected on a particular party ticket, and when they get to Parliament, they just cross carpet at their own convenience without recourse to the people who elected them to Parliament. Now, that brought about a lot of distortion in Parliament, and that brought about a lot of frustration, and that brought about a lot of corruption. The principle we want to establish is that sovereignty or a position that you acquire, whether in the executive, in the legislature, in the judiciary, is emanating from the will and the wish of the people. So if it is the wish of the people of Zebula that I should represent them on the NDC ticket, and I come to Parliament, I have no right to change to another party or become an independent candidate unless I go back to the people. And then they will then confirm or endorse my change. Without having gone back to the people, whatever I do is null and void. That is the purpose of the Article 97 of the Constitution.
Right.
To avoid corruption, and then to avoid taking the people's rights they have given for granted, to avoid abuse of power, etc., and betrayal of the trust and confidence of the people. That's the spirit behind Article 97. And as I drew the attention oral member in the House the other day, if you look at Article 1 of the Constitution, they say that the sovereignty of Ghana derives from the people.
That's right.
If you look at Article 36 or 35 of the Constitution, dealing with the directive principles of state policy, it says that for democratic rights, sovereignty resides in the people. And then therefore, the people's interest or rights must prevail upon whatever you are doing, etc. I can continue referring to various aspects of the Constitution to talk about the spirit of the Constitution. So Article 97 is making the letter of the Constitution deriving from the spirit of the Constitution. So what has been happening of late for the past few weeks is very, very simple. We must be discerning, we must be disciplined, we must be honest with ourselves. If those three people who are NPP are going to become independent and then also to join an NPP, the day that you file your nomination with the Electoral Commission, that you have no more business doing with the party for which you came, that brought you to Parliament, or the people that brought you to Parliament. The day you file your nomination with the Electoral Commission to contest on a different party ticket or to become an independent candidate, then that day you cease to belong to that party and you cease to be the MP representing the people of that in that party. That is very simple. It is to avoid this collusion, is to avoid this corruption, is to avoid this taking the people's right, the people's chance of giving you for a right. That is the rationale behind it.
I see.
So, if like the former Speaker of Parliament, Deputy Speaker of Parliament, he in 2020 betrayed the party and went independent, they sacked him. Today, he came as an independent. The people said, "Look, as for MPP, forget about it. The people of Formula, we like you. So come as an independent candidate and stay our affairs for the next 4 years. Don't change your mind. Don't do anything. If you want to change your mind, come back to us." They didn't go back to them. They just went ahead and filed their nominations. The 4-year period ends on 7th of January 2025. So between now and that period, you have ceased to belong to the party that brought you to the Parliament. You have ceased to belong to the people that made you independent in Parliament. And I think that we have regard to the spirit and then the letter of the Constitution, those MPs must vacate their respective places in Parliament. That is the fact of it.
If the Speaker of Parliament today doesn't reason the way you are reasoning, and I'm sure he's also very much aware of the spirit and the letter of the Constitution because he's also a very old guard. If he doesn't reason the way you're reasoning now and today, would you be disappointed?
Yes, with the greatest respect, I will be. What the Speaker need to do maybe is to request the Electoral Commission to give him certified documents regarding the candidature of those MPs affected. And when the Speaker gets that one from the Electoral Commission, it is a conclusive evidence that they have switched camps or they have changed parties or they have changed their independent status. I do not think and I do not expect that the Speaker will go outside contrary to the spirit and letter of the Constitution provided under Article 97. He will have no justification to do that. I have been following the recent undertakings by former Speaker of Parliament, Professor Aaron Kwe, Michael Kwe, whom I respect so much. And I think that he's involved in double standards, and then I didn't expect that somebody of his caliber can do that. He made a very lucid ruling in 2020. I have read the ruling, and I'm very, very satisfied with it, and I respect him for that ruling. And for him to come today and say the facts are different, I disagree. For example, he's saying that Honourable Haruna Idrisu, who petitioned or who notified the Speaker, doesn't have interest in the matter. I'm surprised about that for two reasons. One, Haruna Idrisu is a member of the NDC. Haruna Idrisu is a member of the NDC caucus in Parliament. Indeed, to the extent he was a minority leader of the party.
Right.
The party has interest in this matter because the party wants to become the majority in the House and not to continue to be minority. We are minority, not that we like it so much, but it's called the decision of Ghanaians. So if we go to the Constitution and then Haruna Idrisu draws the attention of the Speaker, he has an inherent interest. So to suggest that he is not interested in the party, I think that is a greater respect, a wrong assessment of the situation. Haruna Idrisu has interest in the matter because his party and himself will now go to the majority side and not more the minority side.
I see.
And secondly, it is a constitutional matter. As far as constitutional matters are concerned, you don't need to have direct benefit once something is infringing or breaching the Constitution of 1992, any Ghanaian citizen has the right to go to the Supreme Court or to any forum and say that, in fact, the fellow has gone contrary to the Constitution.
Right.
And it's just like me and you are citizens of Ghana. We are not members of the security. We are not police or army and extra. But if you are in your office or elsewhere in the market square and somebody is committing a crime, you can arrest the fellow. You can stop the fellow.
Citizens arrest.
Because you are a Ghanaian citizen. You don't need to be a policeman before you effect arrest when the offense is committed in your presence. It's simple. So there are two reasons. One, any interested Ghanaian can go to court, can go to the Supreme Court and draw the attention to constitutional breach or infringement. You don't need to have personal interest.
Uncle, if you look at the 2020 situation, the New Patriotic Party wrote to the Speaker of Parliament. The question now being raised is that the NDC has not written to Parliament, neither has the NPP written to the Speaker to say these persons stood on our ticket and are in Parliament as we speak. But now they have told us that they want to run independent. We believe that they no longer belong to our fold. So kindly take steps to take them off. Both NDC and NPP have not written. But what do you say to that?
I agree with you. That is very simple. If you read Article 97 very well, it does not provide anywhere that the party or interested party should petition the Speaker or the court. It doesn't provide that. It just says that if you, a sitting MP, decide to defect from your party to another party, you cease to be a member of Parliament. Anybody who draws the attention of the Speaker to this provision or the court to this provision is home and dry. We don't need a petition from the NDC. We don't need a petition from the MPP. The Constitution is very simple. It doesn't provide the criteria that, if you bring this provision and then your party petitions, or somebody petition, that it should happen. It just says if the breach takes place, if the offensive conduct takes place, then you leave the Parliament. And it is, if I'm not reason for that matter, draws the attention of the Speaker. It's illegally correct and sustainable.
I see. You are an officer of the court, Uncle.
Yeah.
Wouldn't you rather wait for the Supreme Court to give an interpretation of this law before Speaker Bagbin, who also is an officer of the court, takes a decision?
Yes, that's another legal argument that the majority leader tried to convince or persuade the House. With a great respect, the majority leader is jumping, is putting the horse before the cart. You go to Supreme Court to complain about a breach of Parliament. It is when an officer fails to take an action that he's supposed to do, that will bring man down to compel him to do the action, or takes an action you think that it is infringement against the Constitution. Then you go to court. The matter has just been notified to the Speaker. No action, the Parliament did not do anything, or the Speaker did not do anything. And before we started the debate, he had filed a petition in the Supreme Court. How can you prevent somebody from doing something he has not yet done? It is when we take an action, if the Speaker comes out with a ruling, and he's dissatisfied with the ruling, then he goes to the Supreme Court. But the mere fact that somebody has raised an issue before Parliament should not look at it, Parliament should not work, that is injuncting Parliament from performing their duty. The three arms of government are independent of each other as far as their functions are concerned. So one organ cannot prevent another organ from taking an action or perform its function. It is when they perform their function and you are not satisfied, then you go to court or you challenge them. But you cannot contemplate.
If
putting the horse before the cart. You should have waited. The Speaker gives a ruling. If they satisfied, can go to challenge that. But you don't say Parliament has no right to look at it.
Uncle,
that means Johnny.
Yes,
that means any bill that the government brings to Parliament, and we have not even gone through the first reading of the bill.
Right.
Somebody can go to court and injunct Parliament that we shouldn't look at it. I mean, then that was the democracy, what's the constitutional rights that people have.
Uncle,
it's premature.
Uncle, this
argument is premature.
I see. Uncle, this is somebody will say extra time of the 8th Parliament, extra time of the government, or if you like, injury time. If your side becomes majority in Parliament, what at all can you do with it?
It's not the issue of making achieving something, this or that. We would have achieved constitutional democracy. We have deepened the democracy that we are practicing. We have respected the constitution that we are practicing. And as I told you, the principle behind it, the spirit behind it, is to prevent corruption, is to prevent abuse of office, is to make sure that people do not take the mandate that the sovereign Ghanaian have given them for granted and betray them. We would have achieved those.
The Honorable Cletus Apol Avoka, Esquire, private legal practitioner, member of parliament for the good people of Zebela constituency, and also a member of the defunct Consultative Assembly that put together the 1992 Constitution. Thank you very much for spending your morning with us. We're grateful.
Thank you, Johnny. Johnny, can you WhatsApp me your private mobile number?
Yes, sir. I shall do that. I shall WhatsApp you.
Okay.
62 will share it with you. Yes, sir. Thank you very much indeed. I'm grateful for the opportunity. And you're live here on 3FM 92.7. This is the Sunrise Morning Show. And just so to put some more perspective on it, I read the provisions of the Article 97, which has been quoted left, right, center by the lawyers and for all arguments. Now, I take you back to the 7th of November 2020. Speaker Bagbin received the petition on the head of the Honorable Esiama, MP for Fomina at the time, who had indicated that he was going to run on an independent ticket because he had lost the primaries. And Speaker Bagbin received the petition on the 13th of October, and he gave a ruling on the 7th of November 2020. Now, here's the ruling as captured in the Hansard. It says, Honorable members, before our visitors come in, there is a ruling I have made on the petition for the declaration of the Fomina seat in Parliament as vacant. Parliament is in receipt of a petition from the General Secretary of the New Patriotic Party inviting the Speaker of Parliament to declare the Fomina seat in Parliament vacant. The Member of Parliament, Honorable Andrew Amoako Esiama, who has been written to, has responded accordingly, and copies are attached to the ruling. The NPP invoked Article 97(1)(g) of the Constitution of the Republic of Ghana 1992, which provides that a member of parliament shall vacate his seat in parliament if he leaves the party of which he was a member at the time of his election to parliament to join another party or seeks to remain in parliament as an independent member. The Constitution of the MPP, which the MP freely subscribes to, provides in Article 3, Clause 9L, that a member of the party who stands as an independent candidate against the officially elected member of the party, or who joins or defers his or her support for another political party or for an independent candidate when the party has sponsored a candidate in a general or by-election, automatically forfeits his or her membership of the party. The moment the MP filed his candidature with the Office of the Electoral Commission to contest the next election as an independent candidate, it shows clearly that he seeks to leave his party. This automatically triggers forfeiture of his party membership. He cannot have the desire to leave, take a step towards it by filing as an independent candidate and yet claimed to be a member of the party. The step taken to contest against his party automatically triggers forfeiture of membership. Having forfeited his membership of a party on which ticket he was elected to parliament, the operative language of the Constitution is that he shall, which is mandatory, vacate his seat in parliament. Going by a purposive interpretation of the present law, constructive actions on the part of the MP is important. With all intents and purposes, he is no longer a member of the party. He has pronounced himself publicly as an independent candidate and has filed papers to compete against the party and its official candidate as an independent candidate on 7 December 2020. On that occasion, this current parliament will still be sitting and operating as an official parliament of the Republic of Ghana. We shall not have a situation adopted freely by any certain MP where he or she would be campaigning openly against the party that he or she still represents in Parliament and yet ridiculously stands against the party. No purposive interpretation of law which allows such ridicule to prevail. Furthermore, after 7 December 2020, when Parliament is still in session till 7 January 2021, how does an MP operate both as an elected independent MP and at the same time an MPP MP if he should win the elections? This lacuna of a ridiculous situation is not what is anticipated under the 1992 Constitution. In the circumstances, it is determined that the conduct of Honorable Andrew Amoako Esiama amounts to vacating his seat in Parliament. Accordingly, we bring this to the notice of the Electoral Commission for the necessary action to be taken in accordance with the law. Signed, the Speaker of Parliament, Honorable Mike Aaron Okwe. All right, Honorable Mike Aaron Okwe is a professor of political science and also a minister of the gospel. This was what he said in 2020 on the 7th of November regarding a similar situation as we have now. Now, the members of parliament who are whose heads are on the chopping board are the NDC's MP for Memphis Central, Peter Yao Kwachi Aka. Peter Yao Kwachi Aka, NDC MP for Memphis Central. Also, Cynthia Mamle Morrison, former Minister for Gender, Children and Social Protection and MP for Agona East. Kwejo Asante of Sohom on the ticket of the NPP. And then the MP on whose head this decision I just read to you was raised or made in 2020 is also in the mix again. Andrew Esiama. Mind you, Andrew Esiama in 2020 had gone to contest as an independent candidate because he lost the primaries and he said he will still contest. He contested in 2020 as an independent candidate and won. In spite of the opposition, the president had gone to campaign against him and said that he would not be able to work with an opposition MP, etc., etc. But he won the elections. He subsequently became the second Speaker of Ghana's 8th Parliament. And now he has crossed into the NPP because he now is the parliamentary candidate of the NPP in the Formina constituency, no longer an independent member of parliament. Now he sits as an independent member of parliament to conduct business with the NPP, that's the majority side in parliament. And this is what Honorable Haruna Idrisu thinks, that, well, you got into parliament on the ticket of independence with the people, you're representing the people. If you so desire to represent the people on the ticket of a political party, then please leave and then let the people have their own, they maintain their position as it is. Well, I've read the details to you. We've given you the interviews. You tell me what's on your mind after this break. Stay with us. We'll be right back.
The luckiest. *712#. Luck is everywhere.